Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host. Today is the 14th of February, 2026. It's a Saturday afternoon, and we are privileged to come your way with another edition of The Community and the Law, live on BWTV, at BWF Solicitors Facebook and YouTube, and at BWTV Facebook and YouTube. My name is Owusu Frimpong. This afternoon, we're discussing the new law on unfair dismissal in the UK. What has changed? Is it good news for employees? We will be looking at that, and we're doing this courtesy of BWF Solicitors, our trusted partners when it comes to the law. 214-218 Tottenham High Road, Seven Sisters, North London. Call them on 0208 493 7340. My name is Oreku Frimpong, and my guest and resource person this afternoon is lawyer Charles Asma of BWF Solicitors. Let's get into it together.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
We are in the month of love, and today is the 14th of February 2026. Obviously, you know it's St. Valentine's Day. Maybe I should have been in red or something, but I've received a lot of red presents on various social media platforms and on my phones, and would want to say thank you to everybody that has felt love and is giving love, and we're giving you love back on this program. Today, we are discussing something that will give you your peace of mind. My name is Oreku Frimpon. The new law on unfair dismissal in the UK. I'm asking what has changed. Is it good news for employees? We will be finding out because Lawyer Charles Asma is here. Lawyer Charles Asma is a solicitor at BWF Solicitors, a trusted partners when it comes to the law. BWF Solicitors is there for you, always in your corner, making sure that your applications, your legal matters, and all the other bits about it are dealt correctly. And you have the confidence to face whatever questions are posed. And when it is that you have to put in an application, definitely you're doing that with confidence. If you have to appeal against the decision, definitely you're doing that with confidence because BWF Solicitors is right in your corner. This afternoon, I have a few updates I want to give. And first of all, I want to welcome to the team once again. Last week we did that, and this afternoon we're doing it again. Welcome to the team, Helena Asma, paralegal with BWF Solicitors. She's joined the team, and lawyer Eunice mentioned that she's brought in a lot of experience. She has practiced in Ghana. She is also here to support the team, and we will be delivering the very excellent services we deliver to you. So, all of you out there will help me to welcome once again to the team, Halina Asma. Halina, thank you very much for allowing us to have the benefit of your experience and knowledge. The people in the community and is happy to do the business with you and BWF Solicitors as we always do. So if you come in, she's one of the very um, highly efficient professionals who will be attending to you. Visit BWF Solicitors on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters in North London. You can call on 0208 493 7340 0208 493 7340, or you can text and send WhatsApp messages or even call the UK number 077 127 61884. Many people also use the services of BWF solicitors, and they give us the feedback that they are satisfied with the service. They also tell us what their concerns are. One I have picked is from Nana A, and Nana is saying that I can never express my gratitude enough, first to God and to Uncle Ben and his team. Thank you, Annie. Very welcoming and patient. With all that is going on with immigration, Uncle Ben and his team make it so smooth. The teamwork and the confidence they put in the work is beyond words. Thank you so much, Uncle Ben and the BWF Solicitors team. I really appreciate you all, and God continue to bless the work of your hands to his glory. One from Nana A, and that's a satisfying story and feedback given by one of our clients. If you have anything to say to us, if you have a concern to express to us, you have a question to ask, you can contact us, as I've mentioned, and I'll say again, 0208 493 7340. Those of you in Ghana, there's an office where you can contact us. The number is 055 589 5959. 055 589 5959. And if you want to call anytime, any emergency situation, you can call the UK number 077 1276 1884. 077 1276 1884. BWFsolicitors.com is our website address, and our social media handles. You can find us at BWF Solicitors, Facebook, YouTube, LinkedIn, TikTok, and any social media handle you are on. We're talking about unfair dismissal reforms that that is going to happen really on the 1st of January 2024, 2027. How am I going back? 2027. We're in 2026, so we have a whole year to look at this. Now, the law is saying, or let me put it like BWF Solicitors is helping us to know that from the 1st of January 2027, the qualifying period for unfair dismissal protection in the UK will be reduced from 2 years to 6 months under the Employment Rights Act of 2025. Continuous service starts on the employee's first day of work and ends on the effective date of termination, that is EDT. Employee or employees hired after the 1st of July 2026 will gain protection once they reach 6 months service. The Employment Rights Bill is now the Employment Rights Act of 2025. It became law on the 18th of December 2025. You know what? This is a nugget, this is something, an update, and we will be dealing with this as our main topic this afternoon because remember the question I asked that the new changes isn't good news. We will be looking at that. We'll be looking at the law in itself as it existed, as it exists now, as it will be changing from the 1st of January 2027, and who qualifies under that. Why is it that it is good news? Why would it go against anybody, if anything? Or what are some of the things you need to know when it comes to the Employment Rights Act of 2025, which was before in a different form, a different name, and what improvements have there been under it? I will be asking you questions. You should be putting your questions together and sending them over to us so that lawyer Charles Asma will help us do that. But in the meantime, let me do some house cleaning first. First of all, let me welcome to the show lawyer Charles Asma, and then I'll come to the platform Facebook, YouTube, um, BWTV, and BWF Solicitors, and also pick up the very few people who have come in. What we do is we ask you when you join us to announce your presence, like the page, click on the notification button so that when we are air, you will be notified straight away, and also share with your friends so they can also enjoy the very valuable content we are going to share this afternoon. So, first of all, Lawyer Charles Asma, thank you very much for coming on the show and welcome.
Thank you. Thank you so much.
We have missed you for the past 3 weeks, maybe. I know duty takes you elsewhere.
All right. Yes. So I think I was covering the Fridays,
Mm.
and so my senior colleague was covering the Saturdays. But it's all in the interest of the community, and we, regardless whether it's Saturday or Friday, we've been able to deliver to the community.
Well, the community, as you know, I just read one feedback from one of the many clients who has expressed satisfaction as to your teamwork, your ability to deal with any issue that comes your way, and the rest of it. I often ask how you react to these things, but I would want to, on behalf of everybody that patronizes your services, to say we are grateful. Especially Nana A is saying, God bless you beyond words. It makes you feel good, I guess.
So the joy and peace derived from the service is that you've been able to make somebody smile, and that whatever they were going through before encountering you, meeting you has made a difference.
Right.
And one thing that most people go through is immigration challenge, employment challenge, and so many other challenges that a lawyer's involvement or input makes a difference. And so when people encounter us and they are able to obtain or realize what they sought, they sit back and say, wow, if not, that wouldn't have happened. and that empower us, inspire us to do more. So our brother Nana and many others who encounter us, your words, your feedback inspire us to do more. We say thank you.
Well, thank you, Nana, as well. And with that, as I said, I was welcoming Lawyer Asma. And having felt good, I feel good as well.
Yes.
Welcome to the show. Yeah.
Thank you. Let me add to that point. There was a case that came to us. I was handling that case. The whole thing was that, I think I've mentioned before, this person was dismissed from work, caregiver, dismissed from work on the 11th of May 2025. And she thought that, you know what, I've been dismissed, I'll find else where to go, find something else. Didn't challenge. Then October, November thereabout, she receives a letter from DBS to say that your employer has reported you to us, that you did X, Y, Z, you've been dismissed, and now it's our turn to bar you from working with children and adults. That's a shocker. Yeah. When she thought, I know, I'm going to find another job, this is a shocker to her. So she comes to us, what can we do? Well, we're going to make a representation. Sat down, looked into the matter, and I picked one thing. It happened on the 10th of May. It was a weekend, Saturday. 11th of May, Sunday, the employer claims to have completed the investigation and terminated. The employer goes on to say that they contacted the CQC as part of their procedures. They informed the CQC, they informed the local council, LADO, the local authority, the designated officer for safeguarding. They contacted them. They did everything they had to do, and now they are telling the DBS, all within the weekend. That's a hang on.
This was on a Saturday.
Everything
and completed on a Saturday.
On a Sunday.
By Sunday it was over, and Monday they have dismissed it.
Yes. So, and even that included their internal investigation.
And who was working on this?
Well, so I said, you know what, no problem. So I wrote to the employer. So DBS asked for a response by the 6th of January. And it was about, so she came to May around the Christmas time when we're about to wrap up. So I said, that's fine. You got by January 6th to respond. So I had to do background checks and so on and so forth, tested the law, the Safeguarding Act, the Children Act, and so many other laws, especially the 2014 Care Act. And they all point to the fact that there should be adequate investigation. And the local authority, if found the need to look into, will have to look into. I said, how can all this happen within this Saturday and Sunday? Something doesn't. And so I approached the employer. I need A, B, C, D, E from you. I need the policy for this disciplinary policy. I need the investigation you carried out, the outcome. I need this, I need that, including the CCTV footage. They didn't respond. So I wrote back on the 6th of January to DBS to tell them that this is what I've done. There's no response. It appears that there's malicious intent to dismiss with a view to bar and blah, blah, blah. I put all the argument. And I said on that basis, there's what we call a balance of probabilities. The balance of probabilities will be that the dismissal is not fair, and so blah, blah, blah. So they wrote back to me for my client to say that we are looking into your matter. We have suspended the plan to bar pending further investigations. Yesterday, I was on my way home around 1:35 a.m. from office, and this client had sent me a letter from DBS. So I read the letter, and DBS is reiterating no action letter. So I read it. I called the client. Well, it's late, but I'm sorry to call you at this time, but I just saw your thing 3 minutes ago. And so I received this letter. I don't know what it's also, but they said no action. I said, oh, okay. What am I saying? they've looked into it and they concluded that there's no point to bar this person from active care practice as a carer. And that is a joy to this person, because she was completely shattered to the point that even when she was looking for nanny work, she was told that because of the investigation by DBS, they cannot hire her, so she had to wait. And for somebody like this, having a representation from a legal person who knows what he or she is doing makes the difference. That is where feedback like this go a long way to inspire us to do more.
So when situations are dire, when people approach you, does it push you? Does it put you back to say, well, this is something we can't do anything about? So you ask the person to go away, or you do everything to try and mitigate situations for people?
Remember, this is legal practice. And with any other practice, you have to look at the circumstance and see what to do for the person. Somebody comes to you with an issue, and the issue is underpinned by the law. So your job is to assess the issue, give it context, and give it merit, and tell the client that on a balance, this is your chance. Therefore, you can pursue it, but at least you have your expectations managed. And based on the scale of preference in terms of expectation or potential outcomes, either you give the client 50% hope, 90%, there's no 100%, 90% hope, or below 50%. But even if the person has 1% hope, it is worth testing. And so you give the person that point and manage the expectation with the person. And you say, well, this is what the law says, and this is what it is. Of course, if somebody has misbehaved and CCTV has captured the person, so be it, isn't it? But the procedure wasn't followed. And it appears that everything was harsh. You know, the employers, especially in the care sector, they just want to get rid of you, and you'll find any excuse at all to get rid of you. And it takes a lawyer to go deeper and say that, hang on, yes, you are right to do this, but you are wrong to have done it this way, and therefore doesn't make what you've done right. And DBS, they are not there to punish. They are there to ensure that people's lives are safeguarded. And so if the person is genuinely harmful, then they don't have to allow them to practice. But if they are genuinely being punished to prevent them to perform their role, and that's also not fair not to allow them to. And your job as a lawyer, for example, is to look into cases like this, be it immigration, be it employment, be it dispute resolution. Today, somebody called me, sought advice, and said that she's received a letter from the magistrate court through the police to either plead guilty or not guilty because, and I said, what's the offense? Not drink driving, but driving without 1, license, and 2, no seatbelt, and 3, having children. Yeah, so you are not qualified to drive. So you are driving in itself is you are driving your provisional license. So that's an offense. Unqualified driver. 2, you have children in there. That's even worse. And the third point is that you don't have even seatbelt. So they picked up on us. So you're asking, what do I say? If I say this or that, will it affect my future immigration applications and all that? I said, first things first. What if you can't deny whatever has happened? And I said, has the car been taken away? Yes, it's been taken away. That even makes it obvious that it happened. So I said, okay, go plead guilty. And that's the first point. Whether online or at the magistrate court, you have to plead guilty because that is the case. But then they will look at the circumstance and give you, the worst case is that they will ban you from driving
for a period
after you have qualified. But the moment I don't qualify, they can't even ban you from driving. But the moment you qualify, you have arrears to clear. So I told her, you may have arrears to clear, but that was something, so be it. And she was asking, would it affect my immigration status? I said, don't worry. When we get to that bridge, we'll cross it because it's too early to look at what the impact this will be. She was asking, will it also affect DBS? I said, don't worry. When we get to the point of DBS, we'll deal with DBS issues. And so she's now, oh, okay, all right. And then she said, I'm now relieved. I'll go ahead and plead guilty and update you further. So that's what we do as lawyers, using the law to support individuals within the context of their issue in a way that reduces stress gives hope, but at the same time, managing the hope for them and working with them every step of the way. Going, and making sure that you get something positive for the client.
This is the reassurance that you get from BWF solicitors when you visit them and put your cases before them. They will work with you throughout your case so that you get a favorable response and result. Contact BWF solicitors on 0208 493 7340 0208 493 7340. Those of you in Ghana, 059 589 5959 or 004477 12761884. BWF solicitors are trusted partners when it comes to the law. Now, this afternoon, as I said, we're going to have a very interesting, very cogent discussion about unfair dismissal and the reforms that are going to happen from the very 1st of January 2027. Now, let me go to the platform as I promised and to acknowledge those who have joined us and have announced themselves. If you do, please make sure you have announced yourself. Sandra Fraser, good afternoon, says, Sandy, thank you very much. Valid viewers, Sandra is welcoming you on our behalf as well. Greetings to you and welcome to the platform. Please share when you join. Emmanuel Kwame Mpiao is watching. Ima, where are you watching from? If you could let us know, that would be also brilliant. Good day to everyone from Citizen Kwejo. Thank you, Citizen. God bless you. Adu Enoch, 7372. Thanks for the education. We are enjoying. Oh, we're so privileged to be providing you content that we enjoy, and we thank you for enjoying and expressing that as well. Adu Enoch, thank you very much. Mami Indabozo, good evening, everyone. Mami, how are you? I know you're doing so very well. Thank you so very much for joining us. The next is Adesafo. Please share when you join. Thank you, Adesafo, for your contribution and your admonition as well. Well, we're moving on and want to say thank you to BWF solicitors again. And when we come, we're delving straight into the discussion. If you have a question, you can text it to 07399 208 468. Or when the lines are active, you can call in on 0208 493 7345. The program is The Community and the Law and is brought to you by BWF Solicitors.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Thank you for still sticking around and welcome to the program. If you just joined us, it's a community and the law is brought to you by BWF Solicitors. I mentioned earlier on that this afternoon we're going to look at some employment and employees' right. And Lawyer Charles Asma from BWF Solicitors is here with us to help us do that. Now we're talking on fair dismissal reforms from the 1st of January 2027. My question is, what do you need to know? Let me reiterate that before I bring on Lawyer Asma to really expand it so very well. From 1st of January 2027, the qualifying period for unfair dismissal protection in the UK will be reduced from 2 years to 6 months under the Employment Rights Act 2025. Continuous service starts on the employee's first day of work and ends on the effective date of termination, that is EDT. Employees hired after the 1st of July 2026 will gain protection once they reach 6 months service. This is from the Employment Rights Act of 2025. The Employment Rights Bill is now the Employment Rights Act 2025. It became law on 18th of December 2025. So I'll first ask that technical question. There's the bill and an act. What's the difference? I believe that will help us to some extent. Why do we have to go from a bill to an act, and what happens between that? Then we'll come to the substantive matter of employment right, the employee's right. I know the employers have their rights as well. That's what they have been exercising, where you'd have to work with them for 2 years before you can get some protection under the employment rights and all the rest of it. So, Lawyer Asma, once again, thank you very much for joining us and welcome to the show.
Thank you.
Now, I mentioned that you lawyers and your technicalities, a bill and a right, an act, a bill and an act. What's the difference?
So a bill is the proposal.
Okay.
Let's put it like that.
Okay.
The intention of Parliament to do something.
Mm-hmm.
And that will always start from one of the people or MPs.
Okay.
So somebody will propose a law or a point of law,
Mm-hmm.
and will be looked into.
Right.
So at that point, it's a bill or proposal that will have to go through the stages of legislation.
Okay.
So it will be read, it will be scrutinized, it will go to the House of Lords for them to also have a look. And finally, it will go to the King for accent.
Mm.
Once the King approves, it becomes an act of Parliament.
Then it becomes law.
That's
in itself.
yeah. So this one was the Employment Rights Act bill to make changes to the existing law on employment rights, which is the 1996 Employment Rights Act.
Mm-hmm.
And having received royal assent, and in December 2025, it is passed. And so we now have Employment Rights Act of 2025. That's the difference. Bill simply means
The
intention to amend an existing law or intention to bring in a new law altogether. And that has to go through the steps and processes, scrutinies. And once it passes the process, it becomes law once the King has approved it.
Yeah, so what existed before the 18th of December 2025 assent, which has become an act? what existed?
Okay.
What employment right are we talking about?
Sure. So we have the Employment Rights Act 1996. And the Employment Rights Act 1996, there are different sections. Section 1 will tell you that if you hire somebody, these are the terms and conditions. We call them the terms of engagement. Let's call it contract of employment. So contract of employment is set out under Section 1 of the Employment Rights Act, the date of employment and all those stuff. And the employer must give to the employee before the start of the engagement. If not, then there's breach under Section 1. Then Section 94 gives protection to an employee who has worked with the employer for 2 years. And that protection, okay, who has worked with them, or who, like at this stage, let's just put it, 94 gives protection to the employee not to be unfairly dismissed. So Section 94 says that the right, an employee has a right not to be unfairly dismissed by the employer, full stop. What it means is that if an employee, you cannot be unfairly dismissed. That means he can be dismissed, but if it is not fair, then that becomes unlawful. So there are aspects of dismissal. We have constructive dismissal, we have wrongful dismissal, and unfair dismissal. Constructive is where I leave the job because of your behavior as an employer. So who pushed me away?
The employer did.
That is constructive.
Okay.
You didn't have to tell me to go, but everything pointed to the fact that you wanted to push me away.
You didn't want me there.
Exactly, and so I left. I have to demonstrate the act that made me leave to make it constructive. So constructive dismissal is not a protection matter for the employee. Then we also talk about wrongful dismissal, where you have been dismissed without due process. That's wrongful. Then we say, is this dismissal fair or not fair? If it is not fair, then why do you dismiss? If it is fair, then employee has no basis to argue because it is fair. Then we go to Section 95. That talks about dismissals, that grounds for dismissals that may be fair.
Okay.
So grounds dismissal that may be fair, we have what we call gross
misconduct.
Summary dismissal.
Okay.
Summary dismissal borders on misconduct. And if the misconduct is gross, then that gives room for summary dismissal. That would be fair.
Okay.
Then there's termination. Your contract ends tomorrow. And if tomorrow comes and I end your contract, is it fair?
That's what you signed
Exactly. So that's termination. And that is good for people who are on contracts.
Okay.
Contract that is with expiry date. If you are a permanent employee, then there's no termination, can only be as a result of any event that might have happened within the employee's handbook. So, producer, if you take us to Section 95, let's touch up on matters that will call for fairness in the dismissal. Okay. Section 95. So, Baguku, just help us with that.
So, Section 95 is talking about circumstances in which an employee is dismissed. And for the purposes of this part, an employee is dismissed by his employer if, and subject to subsection 2, only if A, the contract under which he is employed is terminated by the employer, whether with or without notice.
Full stop. So the contract is what? Terminated. So let's call it termination.
Okay.
So termination is grounds for dismissal. Right.
Okay. So B, he is employed under a limited term contract, and that contract terminates by virtue of the limiting event without being renewed under the same contract.
So the first part is when the contract is terminated as a result of any behavior that has arisen that goes against, for example, the employee's handbook. But the B is talking about where you have a limited contract, let's say 1 year, 6 months, 3 years contract, and the time is up or it's ended, you can be terminated. And we go to the next part.
And it says or, so we looked at one A, B, and or C. So under of these circumstances, as it were, the employee terminates the contract under which he is employed with or without notice in circumstances in which he is entitled to terminate it without notice by reason of the employer's conduct. Sorry.
Okay.
Is that the one you were talking about?
Yes, so,
Construction
yes.
and dismissal.
So, but here it says that an employee shall be, is that the one? The conduct?
No,
go back.
There's the C is what I was talking about. So it says the employee terminates the contract under which he is employed with or without notice.
So this is who is terminating?
The employee.
And that is the one I was talking, constructive by virtue of the conduct of the employer.
Okay.
Yes.
All right. Then we're looking at number 2. An employee shall be taken to be dismissed by his employer for the purposes of this part if A, the employer gives notice to the employee to terminate his contract of employment, and at a time when the period of that notice, the employee gives notice to the employer to terminate the contract of employment on a date earlier than the date on which the employer's notice is due to expire. And the reason for the dismissal is to be taken to be the reason for which the employer's notice is given.
Then we go down.
Textual amendments.
Was that the end?
Yes, that's the end
95.
of 95.
Okay. All right. So we know that under 95, an employee can be terminated on the basis of employee's own behavior, or the employee can also terminate his or her own contract by virtue of employer's behavior, or the contract can be terminated by virtue of the time that has expired within the agreement.
Mm-hmm.
Yes. So it's clear. But when we go to 94, it says that in all circumstances, the dismissal must be fair.
Mm-hmm.
And under one of the things that will make the dismissal fair is if it's by virtue of or operation of law.
Mm-hmm.
If there's operation of law, where let's say somebody is under investigation and the person has been found culpable and proven, then the person cannot continue to work.
Mm-hmm.
Like we're talking about somebody who is being, who is going to face potential charge for driving without license.
Mm-hmm.
If the person is a caregiver and the person must drive to work, and the person has been banned from driving, then you can't drive to work. So on that basis, by operation of law, you have to be dismissed. Mm-hmm. That is fair. Because you can't perform because of whatever. Whether it is because of this or whatever the reason, but operation of law.
Mm-hmm.
Or there's what we call economic other matters. So economic and other matters where we have economic reasons, organizational reasons, and technical reasons. So economic, technical, and organizational reasons, ETO. So when there are ETO factors, ETO, economic factor, for example, due to the economic restructuring, it could be COVID issues, post-COVID matters, and so on and so forth. If we are not running that service any longer,
mm-hmm.
what's your use then?
Obviously.
And if you say everybody must go, is it fair? Yes. Economic reason mm-hmm. makes it a fair reason.
Okay.
Technical reason. We are going automobile. No more hands. All you can use your hand. You have no use of IT. Mm-hmm. Or you don't have any IT expertise. So if we are all going IT and you can't perform, can you go with us?
No.
And therefore, on technical reasons, you have to be terminated. Is it fair? Yes. Mm-hmm. Organizational reason. We are downsizing. We are moving. After Brexit, most companies moved from Britain to elsewhere mm-hmm. due to political reasons. Mm-hmm. And therefore, if it's an organizational reason, that department must be downsided, or that department might be scrapped, or that service must be ended, and you are in that department, will you still be there?
No.
But does it make it fair? Yes. Organizational reasons. So we have economic reason, technical reason, organizational reason to make it fair. We also have legal reasons to make it fair. If the government is saying that certain group of people cannot work, in certain industries, then you have to let you go. Legal reason. You are under investigation, legal reason. You are not supposed to do something, you do something, legal reason. And so that one, you caused it, you have to go. So legal reason will make the dismissal fair. Economic, technical, organizational reason will make the termination fair. And also the end of the fixed contract will also make the termination fair.
Okay.
Now that we know that these are the reasons for termination, we are looking at the bit that will not make it fair. And we are told that if it is not fair, then an employee cannot be put in that unfair situation of dismissal. So 94 says that an employee has the right not to be unfairly dismissed. But it doesn't tell who that employee is. So we go to section 108, and it's clear who that person is.
So let's have a quick look at section 108 of the Employment Rights Act of 1996. Now, 108 says qualifying period of employment. And it says section 94 does not apply to the dismissal of an employee unless he has been continuously employed for a period of not less than 2 years, ending with the effective date of termination.
What it simply means, if the act or the event that caused the dismissal, or we call effective date of termination, is today, the very day the employer says, stop, leave, don't come back, that's the date of termination, verbally, written, or whichever way. We have to count back 2 years to say that your bit can be looked into. Your bit can be looked into means that your right under 94 can be invoked on the basis of 108. So what it means is that if you've worked with the employer before now, if you've worked with the employer for, let's say, 1 year, 11 months, and the employer is trying to play games, then they can work out, let's be quick, so that they don't invoke their right under 94. But 94 says it cannot be unfairly dismissed if you have done 2 years with the employer. And 2 years is absolute. And so if I know I'm going to terminate you tomorrow, and tomorrow will mean 2 years, 1 day, then I have to terminate you last week.
So let me bring it down to the ordinary person's level. I have worked with company XYZ, and for some reason they want to get rid of me. It doesn't fall under the economic, technical, and organizational reasons. Probably they feel that they needed my service for a year to their own gate. And then 1 year, 11 months down the line, they say, unfortunately, we can't work with you. And they don't give me any tangible and cogent reason. I can't challenge them because I haven't worked with them for 2 years. Is that what the law says?
So under Employment Rights Act, you cannot bring a claim for unfair dismissal.
Okay.
You may bring a claim for wrongful dismissal, but not unfair dismissal. Because this dismissal, even though may not be fair, you don't even qualify to challenge it. Because you haven't done 2 years. So contractually, it's wrong. But within the right, as an employee, you have the right to challenge it. The fairness or unfairness, do you have the right?
No, I don't.
Why not?
Because the law doesn't allow me to.
So, but why not? Why doesn't the law allow you under 108? Because it says you haven't done 2 years.
So you haven't done 2 years.
You must have done 2 years.
Yes.
So if you haven't done 2 years and you think it is not fair, can you bring action for unfairness? No, because the qualifying period is 2 years under 108. That was the bane.
Well, that in itself wasn't a good law, really.
Yes, and that is why the framers of the bill, which is now Act, saw the need to amend 108 so that qualifying period of 2 years will be reduced to 6 months. Because once you've gone through probation, you have become an employee.
Yeah, that was a point I was going to raise with you, that for most organizations, 6 months is enough to prove that I can work well, so you can make me properly established in the organization. Then after the 6 months, You are telling me I can't bring any case against the employer for unfair dismissal. Then I didn't have to go through probation. The probation then should have been 2 years rather than
So
six
the
months.
probation will only be for contractual reasons, not
Okay.
employment rights reasons
Okay.
before. But then there must be parity because it wasn't fair.
Mm-hmm.
And so the parity now is that the moment you pass probation, if worked 6 months, especially where the probation window is 6 months,
Mm-hmm.
some companies will have probation of more than 6 months. But whether the probation is going to be extended or not, you've done 6 months. So the question will be, should you pass your probation to become an employee or not? It says 6 months. So whether you pass the probation or you don't pass the probation, you become an employee. So what's going to happen?
Mm-hmm.
Can preempt. If we know we can't let you pass 6 months, we'll tell you that you don't pass your probation by for the month 4 or month 5 or 5 months, 2-3 weeks.
Mm-hmm.
But the moment you hit 6 months, whether you this or that, you become an employee and your right to be invoked under the new law 2025, hitherto Section 94 of the Employment Rights Act, which says that employee has a right not to be unfairly dismissed if they have worked with the employer for 2 years. In this case, if they've worked with the employer for 6 months.
So is it the 108 they are amending now, or probably they are even taking it out altogether?
Then what we have said is that the qualifying period for the employer not to be unfairly dismissed will reduce from 2 years to 6 months. And so it's clear that Section 108 is what is amended. There are other areas that have been amended, but because today's conversation is about unfair dismissal, what was before, what has changed, and whether it's good news or bad news for who, that is the conversation we are having this afternoon.
So if you just joined us, we're live on BWTV and it's brought to you by BWF Solicitors. They don't just only provide us with immigration advice and direction and also supporting us, but some of these rights that we have under the law are being discussed and also promoted. We're looking at the Employment Rights Act of 1996 and the amendment that was made and endorsed on the 18th of December 2025, which has become the Employment Rights Act of 2025. It would be effective from the 1st of January 2027, but we are taking time and the effort to look at what is in there, what our rights are, and what to expect. Unfair dismissal. How do we look at that? How do we get ourselves protected? Even if it is 2 months, do you have your rights protected beyond that or within that period? We will be right back after this message to say thank you to BWF Solicitors. But in the meantime, if you have a question, you can put that in the comment section down below at BWF Solicitors and at BWTV, both on Facebook and YouTube. Or you can send it to our text line 07399 208 468. And or when the lines are active, you can call us on 0208 493 7345. It's a community and the law. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. As I mentioned, you can leave your questions and your comments down below on Facebook and YouTube at BWF Solicitors and at BWTV UK. The new law on unfair dismissal in the UK. We've talked about the law, but let's look at what the law says about an employee. Who is an employee? Is it me, you, or what? Who's an employee?
That's a good point. Look, ideally, everybody who is working for somebody must be an employee.
Mm-hmm.
But the law looks to employees and workers.
Okay.
And within the employee, you stretch it and realize that, oh, this person actually is not an employee to be able to have a right.
Now, you mentioned two things, and as we see on the screen, we have employees and workers. What's the difference?
So, if you are, for example, if you volunteer
Mm-hmm.
with that formal structure, you are working.
Mm-hmm.
You are a worker, but not necessarily an employee
Mm-hmm.
for that employer. If you're an agency worker,
Mm-hmm.
who do you work for? The company or the agent?
You work for the agent.
So, are you a worker or an employee?
Okay.
Are you with me?
Then, you're a worker.
Yeah, then again, you come to my workplace.
Mm-hmm.
You come to work for me, but I pay you and you pay yourself.
Mm-hmm.
All the things that employees must enjoy may not follow the structure or the formal process.
Mm-hmm.
And the question becomes, are you an employee or you are self-employed? So that's what we call contract for service and contract of service. If you are providing a contract of service,
Mm-hmm.
then you are an employee. If you are providing a contract for service, then you are working for yourself. You are self-employed.
The key word here is of and for.
And so, yes. And so you stretch and realize that this person who has been doing everything, everybody thinking that working for the company is actually working for themselves. You are self-employed. If you are self-employed, regardless of how it looks, you have a right within the law. No. You are self-employed.
So I am a bit confused here, and I know you help me understand it. If I am an employee, the conditions of employment outlined by the company affects me. So if there are benefits for employees, I can benefit from it. If there are rights for employees, I can benefit from it. But if I'm a worker, then I fend for myself, even though I'm providing service for that organization. Is that what you're talking about?
So that's the point, because the arrangement, the contractual arrangement will
Mm-hmm.
determine whether you are under the employer
Mm-hmm.
or you are under yourself, literally.
Okay.
But working for the employer. Working for the employer, it means you are providing a service.
Mm-hmm.
You are providing a service within the contract arrangement.
Mm-hmm.
And that is why when a matter goes to the employment tribunal, the tribunal will want to define the person to ascertain whether this person is an employee or self-employed. If you are self-employed, then what's your business in court? It's a contractual matter.
You are your own organization.
And therefore, it's a contractual matter, not employment matter. Okay. You deal with that contractually. That's breach of contract, but not breach of employment contract. And that's why when the case of Uber, the people who took Uber company to court, some of them were deemed to be employees. Some were deemed to be self-employed, depending on the nature of the arrangement. And so when we go into employment arrangement, there is a case law that suggests certain things. Whether you are working for yourself, we're looking at the level of control, we're looking at discretion, we're looking at policy matters. So all these things will then determine whether the person is self-employed or an employee. If an employee, the conversation we are having affects you. If you are self-employed, it doesn't affect you because the employer does not have a duty within the employment law towards you, so to speak. Whatever duty the employer may have is contractual. But because it's contractual, the person is not an employer. It's a party to the contractual arrangement. So these are the nitty-gritties of this aspect. So if you are working for somebody, you should be able to define who you are within the scheme of the arrangement, whether you are an employee. Because somebody says, oh, okay, then they go into it only to realize that you're only providing service to the company. You are not an employee. Because, yes, you may be doing this, you may be doing that, certain things and all that. That could be part of it. But when it comes to the main scope of the law and the policies itself, you realize that, well, because the control is not full, it's semi. Because of this, because of that, for example, who pays the NI, the pensions, who pays the tax, all these things are matters the court will look into to determine whether you work for yourself or you work for the organization. And so once all these are put together, uniform arrangement, that control, and can then determine that this person. And so if we can define who an employee is, then we can tell that if you are not within the scope of definition, you are not an employee. And so the right under Section 94, which is amended to help you reduce the 2 years to 6 months, will not really cover you. So if you look at Section 230, producer, Section 230, for example.
Okay, so we're back with Section 230, and it says, in this act, employee means an individual who has entered into or works under, or where the employment has ceased, worked under a contract of employment. In this act, contract of employment means a contract or service or apprenticeship, whether express or implied. And if it is express, whether oral or in writing. Number 3 goes on to say, in this act, worker, except in the phrases shop worker and betting worker, means an individual who has entered into or works under, or where the employment has ceased, worked under a contract of employment or any other contract, whether express or implied, and if it is express, whether oral or in writing, whereby the individual undertakes to do or perform personally any work or services for another party to the contract whose status is not by virtue of the contract that of a client or customer of any professional business undertaking carried on by the individual. And any reference to workers' contract shall be construed accordingly. Number 4 goes on to say, in this act, employer, in relation to an employee or a worker, means the person by whom the employee or worker is or where the employment has ceased was employed.
Right. So you can see that looking at employee and worker, worker has now been clearly defined to be that if you are working for somebody, then you are a worker of that company, meaning you become an employee. But if you are an employee, you may be working there as an employee, but then we have to look at how the arrangement is. So we can then say, oh, that worker qualifies to be an employee, but an employee may not necessarily be a worker for that organization. Quite technical, confusing,
yeah, it's a bit confusing.
But the most important thing is that what is the level of control?
Okay.
If the level of control is higher for the employer over the worker, then the worker is an employee.
Okay. Can I look at it from this angle? For instance, I am self-employed and I am contracted by, so for instance, let's look at nurses who are on bank arrangements. I am under I-35, that kind of arrangement. I pay my taxes, I pay my NI and all the other bits. But then I provide my service to a hospital, for instance. The hospital has its own permanent workers who have different arrangements apart from me. Then I can see myself as being employed by myself, offering a service to the hospital. So in that case, whatever rights I have within my I-35 arrangement is for me as an employee of that company, but not employee of the hospital that I'm providing a service for. Is that what the difference?
So who is this hospital?
The hospital is not an employer. I'm
Yes.
working for
so the hospital becomes a client.
A client. Okay, yeah, that's the correct term. Yeah.
The client that you are providing the service to. If you look at Section 230, the definition under worker, it says where the person provides the service personally. Personally. So personal service is where you go and do it yourself. But those I-35s, where they have set it, all they want to see happening is that the job is done. But there are certain arrangements where even though you want to see the job is done and so anybody can do it, because of the technical nature of the job, you cannot just bring anybody. You have to personally do it. But however, when, how, where to do it, you may have discretion or control over.
Okay.
So when, how, where you have some level of control, then you are self-employed.
Okay.
And so with those who are on this R35 arrangement, most of them are self-employed and they have to pay their own taxes. Do this, do that, do that. All the client wants is that the job is done. You get your, and those people, they don't get salary. What do they get? Payment for work done through invoice.
That's right. Yeah.
Not pay slip.
Yeah, that's another thing. Yeah.
And so the person may not necessarily be on payroll to be paid a wage or salary. The person will be paid a bill that they have raised for work done. So all these R35 doctors who are doing locum and so on and so forth, they have a contract, come do this to get your money. But then the nature of the contract and the nature of the service, the technical nature, and the rules and regulations that pertains to that service is such that they need you that they know to be competent to perform. So if you are bringing somebody in because you are away, then the person must be vetted by the service user, let's call it service user, the supposed client, to say that, oh, even though the person themselves is not doing the job, this person can equal, and therefore I'm happy for somebody to represent you or cover you for that bit. And that's why some of these self-employed workers, because all we want is the job done, they just go pick somebody. So somebody will get a contract and hire people to go and work for them. And you will say, why did you bring somebody to do it? All you want is the job is done. So only when it goes wrong that there will be contractual breach for the performance. Simply because they didn't have duty, they didn't have the care and diligence to employ people who have the competence to perform. But that is a different conversation. But for this one, what we are saying that workers qualify as employees, but not all supposed employees may be workers for the purposes of rights not to be unfairly dismissed.
Now we're talking about unfair dismissal, and we're looking at who qualifies under that. and you've taken us to the provision that has defined that. My mind goes back to what the law in itself is saying. The amendment that has been assented to by the king and has become the Employers' Right Act of 2025, which was assented on the 18th of December 2025. What are the things that have been looked at? I think technically you may call it the fact sheet. What are those things that have been looked at? If
Right.
we could get some understanding of that, then I'll come to pose my actual question to say whether it's good news or not.
Sure. Right. So we ask producer to assist us with the key points within this amendment. So the fact sheet for the Employment Rights Act. So the key facts. So Brakuku, you are going to take us through the key facts.
Okay. Fact sheet Employment Rights Act 2025. There's an overview, something from the Department for Business and Trade. Now it says that the Employment Rights Act 2025 is a key pillar of government's plans to make work pay, which is aimed at growing the economy, boosting wages, and reducing insecure work. The act was developed in close collaboration with business and trade unions and will help bring employment rights legislation into the 21st century, extending modern protections to millions more workers. So, what measures are contained within the act? Now, it says that the act addresses one sided flexibility, ensuring that jobs provide a baseline of security for workers by ending exploitative zero hours contracts by introducing rights to guaranteed hours, reasonable notice of shifts, and payments for short notice cancellation of shifts with corresponding rights for agency workers.
So the winners, one of the winning categories, agency workers.
Yeah.
Agency worker, I used to work for agents or agencies as a supply teacher.
Yeah.
In the morning, you have to wake up 5 a.m. because school will start by 8. And by 8, if the teacher is not coming, you will be on standby to be called, so on call. 5 a.m. you are ready. But you cannot tell whether you're going to work or not until you receive a call from the agent that, hey, Charles, are you available? Go to this place. This is a postcode. You are going to do a cover. Then you have to put yourself things together. You don't even know the topic. But you are a teacher, and therefore you have to go and deliver. You don't need extreme preparation if you know what you are doing.
Okay.
But then there's uncertainty. They can even call you, book you for Friday. All of a sudden, they cancel it. Meanwhile, you've also canceled another opportunity. Who pays for the opportunity cost? And that is why within the framework of this legislation, I think that they want to end unfairness associated with agency work. So that if you are booked and it is cancelled, they have to pay you for the booking.
Okay.
Because you've also forfeited another opportunity.
You have reasonable expectation that
something. And that is good for agency workers.
Okay.
That's what I see. Let's move on to the next bit.
So the next bit on the fact sheet, we have ending unscrupulous fire and rehire and fire and replace practices by considering dismissals for failing to agree to a charge in certain core contractual terms as automatically unfair, except where businesses are in severe financial difficulties and genuinely have no alternative. Okay, let me try and see if I can understand this from the layman's point of view. Somebody says that I'm going to give you £20 per hour for this number of hours. And then they decide not to pay that amount because certain things or certain conditions have changed. Or they say, okay, well, I'm not hiring you this time, I'll fire you, or I'm asking somebody to come and replace you just out of the blue, just like that. Is that what the second point is talking about?
So with the second point, well, because of the arrangement at the moment, it says that if you are not 2 years, you don't even have a right. What it means is, if I give you opportunity that anytime we need you, we'll call you. Who has control anytime we need you?
That is the person asking you to come.
At the same time, you have to make yourself available anytime. So when we need you and you are not available, you lose. And when we don't need you and you are available, you still lose
because we haven't called you.
There's no certainty. And there's what we call unscrupulous way of hiring and firing people, replacing people anyhow. And what they are now saying is that unless it makes business sense, you cannot pick and choose. So they want to prevent fire and rehire. Why will you fire and rehire? If the person is definitely good, you want to keep them. Why will you fire them and rehire them? It's for economic reasons. Because if I can fire you for 1 week
and rehire
you after that, then I can manage my profitability and cost. But that is not good for the employer, sorry, the worker. And so, even though today we touch up on unfair dismissal, there's more into the act, the amended act, that is helpful. 0-hour contract. What is 0-hour contract? You are a worker, you are an employee, yet you are not. Because when we need you, we'll call you. And when we call you and you are not available, we say, why didn't you come to work? You are not available for work. But how will I know I'm available for work if you haven't given me notice that you call me tomorrow and somebody has given me opportunity and I'm supposed to survive? So 0-hour contract is not good. But again, somebody can say that I'm on a 0-hour contract, permanent worker. But then, imagine somebody bringing a wife or husband from abroad, making application for entry clearance, or even in country, they have to prove 29,000. The person is a 0-hour contract worker. Full-time contract, because the contract says you are permanently employed, but hours is 0. But if the person is lucky enough, they are able to get more than 0. But if they are not lucky enough, they are on 0. So how do you manage your affairs on the basis of 0 hours?
It could be more than 0, but not even up to the point you get the 20.
For example, and so there's one case, the person is on 0 hour, but luckily was able to do a lot of hours, and so we could get the 29,000. So what does the law now say? That rather than saying 0-hour contract, give the person guaranteed hours.
Okay.
So that if it's 20 hours or 15 hours a week, you are given. You know that you work 15 hours. You can plan your life. But 0 hours, just to feel good that you are working. But
obviously,
right.
And it's very risky.
It's risky. And so they have the worker, the employee, the family in mind. And the framers of this bill or the law got it right. The next point on the fact sheet.
Yeah. So if we can go back to the fact sheets, we've touched 2 points. The exploitative 0-hour contracts, ending that, and then unscrupulous fire and hire and rehire, and all the rest of it. Now we go to the next point, which is the third on the point, reducing the qualifying period of employment for the right to claim unfair dismissal from 2 years to 6 months, and ensuring the qualifying period can only be varied by primary legislation in future. The current cap on compensatory awards will also be removed. Something has been introduced here, compensatory awards. And then they also saying that it can only be varied by primary legislation in the future. So does it mean that if it has to change, then they have to change the whole law?
Yes, so by primary, this piece is a primary legislation. So we have primary and secondary. Primary legislation will always come from the Parliament, Act of Parliament. Secondary legislation will be orders, regulations, and bylaws that a minister may propose or the local authority may propose, and so on and forth. Those ones will be like primary. But for this one, because of the nature of it and the impact, what they are saying is that until Parliament sees it fit to amend again, it will remain. And it's good because even if you look at the bit under fire, rehire, fire, replace, they're saying that is no good. And therefore, if you want to do that, have a conversation with the person and say that this is what is going to change. Otherwise, just all of a sudden saying that you are off, come, we need you, will not be fair. It says that such changes will be automatically what? Unfair. Except where businesses are in severe financial difficulties and genuinely have no alternative. In that case, you have to prove that you were in genuine financial difficulty, you had no alternative. So for me, really good. We also see that point 3 talks about changing the unfair dismissal threshold from 2 years to 6 months, which is very good. Then we go on to the compensatory awards. Compensatory awards is where, when a matter goes to court for unfair dismissal claim, there are 3 things you want the court to do. You want the court to make a declaration that this is wrong, unfair. You want the court then make an order that this is not fair. And then you want a court to offer compensation or the award. And the award is calculated. And there are instances, and there are a lot of instances where there is a cap. You won't go beyond that. And the cap is where it looks at how many years you've worked with the employer to determine how much you can get. And so they are going to remove the cap so that people will not be unfairly placed when it comes to compensatory awards. And that is also good news in this piece.
So the next one also says that strengthening collective redundancy rights by ensuring obligations to collective consult and notify the government apply when A, employers propose 20 or more redundancies at one establishment, or B, employers propose a number of redundancies across their entire organization, which meets a new threshold which will be set in secondary legislation. And 2, doubling the maximum period of the protective award for failure to properly consult on collective redundancies, increasing the maximum period from 90 to 180 days pay. That's a long one.
Yeah, the long one. Yeah, all saying that when it comes to redundancy consultations, it wouldn't be business as usual. And therefore, employers will have to be very clear and meticulous. For example, where there's proposal to make 20 people redundant or a whole department removed from the business activities of the organization, then it will trigger wider consultation platform. And where necessary, government will even have to intervene. So what is the government trying to do? Government is trying to make redundancies very robust in a way that it doesn't affect the worker or the employee, but employers take time to do what they have to do in terms of the processes of seeking consultations, giving people opportunity, and where alternatives are available, you do all that. So the bit about consultation or redundancy rights is also very good. Now, the other one about maritime redundancy, that's not common, so we'll skip that. And it says that all the law seeks to do is to ensure that workers get fair pay for fair day's work. And that, talking about, so as part of this, also going to be wages. If you go down to the next producer, wages. So strengthening statutory sick pay, strengthening existing tipping laws, strengthening two-tier code, and so many other things. But for us, and most of the people within the community, it's about sick pay. How much will I be paid when I'm on sick leave? At the moment, it's 5 days. The first 5 days, first week, certified, you have to be paid. Any further weeks or days, then the payment will reduce. The government is seeking to strengthen this approach or make it fairer so that people will not be forced to stay at work, even when genuinely they have to be resting to heal properly.
Okay. Well, the main crux of the matter is the good news that we have the qualifying period for being an employee and also bringing a case of unfair dismissal reduced from 2 years to 6 months. But lawyer, my question again is, it says it's taking effect from the 1st of January 2027, and then says that any person employed from July 2026 will qualify. It was assented in December 2025. Why was it, or has it been pushed to 2027 for implementation to start?
Yeah, I mean,
2027, so to speak.
yeah, enforcement processes sometimes take time, or implementation windows sometimes take time. But if we look at somebody who is employed on the 1st of July, and the law is saying that people employed 6 months will qualify for right not to be unfairly dismissed. In this case, somebody is employed 1st of July, and their rights start from that point. Then 6 months into the contract, they assume that right. So the law cannot be implemented later than 6 months from that date. And that's why it's saying that, so if somebody assumed 1st of July, August, September, October, November, December 6 months. So 31st of December, you would have done 6 months with the employer. My right has accrued, and so I can exercise the right from the 1st of January. So they put all these calculations in there and concluded that this will become law or can be invoked from the 1st of January. What it means is that the moment whoever is going to go through unfair dismissal claims will fall under the existing regime, Section 94 and Section 108.
I have a feeling that probably might be my last question. That the situation has come or has risen because there have been a lot of complaints, especially in the care industry these days, that people tend to dismiss people unnecessarily within the first year or thereabout. In the community, there have been people who say, well, my employer, so to speak, does not have enough of hours and shifts, so they are dilly-dallying with me. Have you had a sentiment like that?
I mean, the point you've raised is a concern for many people, especially those within the care sector. Apart from the hours not being available, if the job is not there, the law says that, or the rule says that the employer must tell the government. And the government will tell the worker, the job is not there, find another one. You are given 60 days. But what if they deliberately want to dismiss you? Somebody will call as a lawyer. This happened at work, and I'm told to leave. This is not about no job. It's about certain behavior. You go into it and realize that the person could have been given a warning. So what are the layers? Written warning, stage 1, stage 2, stage 3, and so on and so forth. So if it's not a gross misconduct, then the person mainly being dismissed will not be fair, but the person will be told stop because of what has happened. Then the person will ask, what are my rights? Then we look at Section 94 and Section 108, only to realize that the person doesn't have any right, or they haven't worked with the employer as a carer for 2 years. Because they started 7 months ago. They started 8 months ago. The employer has the power. After, what can you do? You can't take me to employment tribunal because you are not, you haven't qualified. So the person can only go under contractual breach, but to what extent? Today, or let's say from 1st of January, if somebody is going to go through that, the person can say that that is not fair. I've done 6 months with you. I've done 7 months with you. I've done 9 months with you. So I've qualified. They cannot unfairly dismiss me. What should they do? The case of Birchall talks about the steps to follow if you want to dismiss an employee fairly. Again, ACAS. ACAS is the body arbitration conciliation body that looks to the needs of workers, or the rights of workers and the rights of employers. But ACAS is also clear on the procedures to follow. About 9 steps. 1, what is the policy in place at the workplace for investigating such matters or behavior? Once we know what the policy is, we can tell whether the employer followed its own policy or not. 2, in terms of training and support to prevent further occurrence, did they happen? And so on and so forth. So if there's what we call belief that whatever has happened, happened, and taking steps to confirm that belief and acting on the belief. 3-tier test. So the first thing is something has happened. The second thing is how did you test that knowledge? And the third point is this action fair within the scheme of things? Is this the only action you should take? And if this cannot be the only action to be taken, then we can say that this action is not fair within the scheme of things. And that is, there's case law and there's, again, Employment Rights Act. That's why it says that an employee cannot be unfairly dismissed. It doesn't tell what makes it fair and what doesn't make it fair. That means there are steps to follow. If you go further to the tail end of the legislation, it tells you what the employer must do to make dismissal fair.
Can we quickly look at that? What makes that dismissal unfair and what will make it fair? If you could quickly run us through that.
Right. So I would have taken you to ACAS, but I'll just, for the sake of time, we'll go into that. So the first thing is the termination clause within the agreement or the contract. The termination clause will spell out events that will trigger termination.
Okay.
We saw under Section 95 that one of the reasons the triggers will be end of the contract.
Yeah.
So if the contract has ended and you are terminated, that's fair. But if the contract hasn't ended and you are being terminated, then there must be a reason.
Okay.
Is the reason economic, technical, or organizational? If not, why? Is it legal in a sense that because of what has happened, the person cannot continue to work? And so it's obvious that they have to let the person, they have to relieve the person of the duty. That is also fair. But if not any of this, then it becomes a mistake. If it's a mistake with work would be attendance, punctuality, care as to how you do your work, and so on and so forth. So if the person is not careful and they've made mistakes, and that mistake has caused the employer A or B, and you say on the basis of that you are dismissing the person, would that be fair? Under circumstance, a normal circumstance, you have to what? Point it out to them, take the person through training and warn. So then the first thing is, we have to look at the employment contract, termination clause. We'll have to look at the handbook for the employees. We also have to look at the disciplinary procedure in the workplace. All these things, we have to put them together. Then we'll also look at what ACAS sees it to be fair way of dismissing. And ACAS says that for the dismissal to be fair, one, there should be investigation about the action.
Okay.
And two, the investigation should point to the fact that whatever happened, happened. And three, we have to look at alternative way to avert it. If there is a way to avert it, then it's a matter of training, warning, and support. If all these things didn't happen, and you say that the employee should leave or the worker should leave, then in all circumstances, dismissal may not be fair.
In all circumstances, dismissal may not be fair. Now, listen, I am then now going to ask lawyer, and if you permit me, I would demand a yes or no answer from lawyer before I take your questions and your contributions. What has changed? Is it good news?
So what has changed is that the law has become more favorable to the worker than the employer, and that is good news to the worker. We have a range of workers, and all these changes are good to all the categories of workers. It's good for agency workers. But now the law is saying that the employers cannot play games. I need you, I don't need you. I need you today, stay away 3 months. Are you available? Come. Uncertainty.
It can happen.
Two, in terms of capping, when there's award in court, depending on how long the person has worked and so on and so forth, that is also going to be removed. And so if there is compensatory award, then you have to be given the full threshold where necessary.
Mm-hmm.
Again, it's good for workers generally because after your probation, which is generally 6 months, you have a right not to be unfairly dismissed. It's good for all range of people. The only group of people that this may not be their beef is people working for themselves, because they are not workers or employees.
Well, you may have questions, you may have concerns. It's now time for us to pick a few of them, and then we will move on to draw the curtains down. 0208-493-7345. Lines are active. You can leave those comments in the comment section down below, either on Facebook or YouTube at BWF Solicitors and at BWTV UK. Send a text or WhatsApp 07399 208468. Check the social media handles. I'll be right back. Well, as I said, the lines are active, so I am close to my phone, and you can also leave your comments in the comment section down below. 0208-493-7345. Send a text to 07399-208468, or you can leave them in the comment section down below. This afternoon, I can see of BWF Solicitors, we have brought you the topic, the new law on unfair dismissal in the UK. We've looked at what has changed, and we have answered the question whether it is good news for employees. Yes, let's pick what you have. Samuel Kwabinata comes up with this and says that, lawyer, I am a British citizen. I brought my spouse over with 2.5 years visa. How long can she wait to get indefinite leave to remain?
Right.
British citizen.
So for this person, the period will be 5 years, because the person would have been put under the 5-year route. So 2.5, the person will have to renew for another 2.5. And once the second 2.5 is about to expire, the last 28 days, the person will apply for indefinite leave to remain. Simply 5 years before indefinite.
5 years before indefinite. Thank you very much. Let's pick up another one here quickly. Bafo Bonsu. If both couple are in the UK, can they divorce in Ghana if they gave power of attorney to their representatives and use that divorce certificate here in the UK?
Well, you have to check the divorce proceedings in Ghana. So speak to your lawyer in Ghana and let them look into that. Obviously, you married in Ghana, so you have a right to divorce in Ghana, but you have to follow the divorce processes there. If you want to divorce in the UK, the law allows you, if you have lived in the UK for 1 year, either both of you or one of you, then the UK Family Court will have a jurisdiction to accept an application for divorce from any of you.
Thank you, lawyer. We go to the next one from Sandra Akosia Adepa Chumwa. I want to bring my kids here, and I heard about custody order. What's the meaning of it?
Custody order simply means that the child lives with a particular parent, but that is not what you need to be able to bring your child. So please, Sandra, don't fall for this. I know there are a lot of gimmicks going on through pocket lawyer shops. Be careful, because custody order is a court order telling where the child must live. It does not take away the responsibility of the other parent. So if you are bringing your child, the application will be assessed under paragraph CHI 3.2 of Appendix Children to the Immigration Rules. under CHI 3.2, there are three parts, A, B, C. A, the other parent who is not in the UK must have died. And if the other parent is dead, then the one in the UK becomes the surviving parent. Then it's easier for the child to relocate to where the surviving parent is. Easier. A, is there death? If there is, death certificate. If not, you go to B. B says sole responsibility. Sole responsibility is it's not something that you go to court to collect evidence for. It is not something that somebody will write for you. It's a term demonstrated by what is happening. Case law defines sole responsibility. There is a case called TD Yemen. TD Yemen case, the court said that to show that you have sole responsibility, you must demonstrate that the parent bringing the child to the UK is the one who has control and direction as far as the life of the child is concerned. Control and direction of the life of the child simply means that you are making all decisions pertaining to this child. Educational decisions, healthcare decisions, naming decisions or change of name decisions, friends to keep, where to live, all these things. And so, if you take a custody order and you give it to the immigration officer that, look, I have a custody of my children, the officer will say, well done, you are looking after your child because your child lives with you. But it doesn't mean that the other parent is irresponsible. You may have shared responsibility. And so custody order doesn't prove sole responsibility. Sole responsibility is difficult. Yesterday I was talking to somebody who wants to bring the child. I asked the person, how long have you been in the UK? He said 1 year. And I said, you claim that the other parent is irresponsible and therefore they don't care about the children. You claim that your mother is the one looking after the child and your mom that can't even do the job properly. And yet, being a responsible parent, if never bothered for 1 year, go and find out what is happening to the children. Are you sure you are the only one doing the job for the children? So all these things will come into play to be able to prove sole responsibility. It's not just about the money you send to the children, but it's the decisions pertaining to the life of the child. If not, then you go to C. C says serious and compelling family circumstances in the life of this child that makes their exclusion from the UK undesirable. Simply put, what shows that if the child is not relocated from where they are, they may die. It's a case of safeguarding and child protection. So what is the evidence that something is happening? Any police concerns, any school concerns, any social service or social welfare concerns? What are the issues going on in the life of this child? What have you also done in terms of going to visit to ensure that things are going on well for the child? If you have it, then you can say that if my child is not relocated, it will affect the child's life. And that is a way to get around the application for your child if you want them to join you. So please, Sandra, don't rely only on the custody order from court. It is nothing other than just a piece of paper. Thank you.
Thank you, Sandra. You've had a very extensive response from lawyer, and those are the facts. If you need further support, visit BWF Solicitors on the 4th floor of the other house, 214 to 218 Tottenham High Road, Seven Sisters, North London. Call them 0208 493 7340. You can see their numbers at the bottom of the screen. Let's pick a few more of your concerns and questions. Flip Flex. I have been on a parent route visa for 6 years on a 10-year route. They put me on a 5-year partner route. Can I apply for my indefinite leave, please? One of the very technical questions that normally come. This person is on the 10-year route. He spent 6 years already. Now they've put him on the 5-year partner route. Can they apply for the indefinite leave to remain?
So this is the thing. This person was on the bus going to the destination. And bus, because of the pace, it takes longer for them to reach destination.
Okay.
So this destination will delay for 10 years. The person decides to change from bus to train,
Which is faster.
which is faster.
Mm-hmm.
Remember, you cannot have one leg on the train and one leg on the bus and get to the destination.
Mm-hmm.
And so you've got to decide. And they decided to abandon the bus experience and enjoy train experience by starting all over again, the journey. Because the journey will have to start. So, my brother, because you decided to switch to 5-year partner, your journey began as a partner, and you have to stay for 5 years to move to indefinite.
So, in effect, the 6 years has been wasted.
Well, they chose to change it because for me, if this person came to me for advice, I would have said, you've already done 6 years, you got 4 years to go. If you come to start as a partner,
then
you're only going to start all over again.
So then you're going to spend 11 years.
So what's the point?
Yeah.
Maybe what the person can do is that, okay, I've done 4 years as a partner, 6 years under this. Can I apply on the basis of my continuous 10-year long residence?
Okay.
That becomes a technical, because then you cannot apply as a partner for indefinite. You cannot apply as a parent for indefinite. You're then going to look at accumulation of all your leave. What if you have your indefinite? Because you have decided to abandon the partner experience, and the partner is British. Once you have your indefinite, rather than having naturalization right after indefinite,
you have to wait for
you have to wait because you decided to change to another platform.
Well, I would advise you always speak to the lawyers, and especially speak to people who know what they are about and understand the law. BWF solicitors is one recommendation I will give you. Let's pick up the very last one on the platform and see what it is. Please, what about the child British passport has been issued? Can their mother apply for the parent route through the child's passport?
Yes, the mother can do that. However, let me be kind to caution that at the moment, the Home Office is carrying out sampling investigation and on-spot investigation, depending on whether you are lucky to be investigated or you are not so lucky to be investigated.
Mm-hmm.
What does it mean? They are saying that dating back 2015 to date or going forward, anybody who applies as a parent based on a British child, they want to test how the child became British.
Mm-hmm.
If the child became British through the other parent, who is no longer in the life of the child or this person, man or woman, then they may invite the person making the application and the other parent of the child for them to confirm whether the two of them made that baby. If they're not able to prove that they made the baby, so to speak, then it may appear that the child is not British. But that is something that is happening. A lot of people have had their children's passport cancelled or withdrawn, applications refused. But we've always said, Uncle Ben has done lots of videos and education on this to say that the law is clear. Section 50, subsection 9, capital A of the Nationality Act is clear that we know who the father is and we know who the mother is. And if the father is defined, and the father, we can say that it is the father, then the child's birth passport is legitimate. However, if you are making an application and they ask you to attend interview, you can't say that the law says it's legitimate, so I won't attend interview. Because interview is, again, within the rules, evidential flexibility opportunity for the caseworker to confirm the facts and the claim of the applicant. And so when you are invited to attend interview, you cannot ignore. You must go. And depending on the outcome of the interview, you may be granted a visa or you may be refused and your child's passport questioned. And then it becomes a lose or a loss for both you and the child. So the answer to you is yes. However, bear in mind that they may do what they call flexibility check interviews. And when it happens, you have to make yourself available together with the other parent who got the passport for the child.
No, no, actually, that's very cogent advice for you. As I said, and I'll say to all other people, contact BWF solicitors when you need further explanation and support on this one. Brish Mengels, Kevin Asamoah, Mildred, Antonia Braxton, Kakari Sandor, um, and many others who have joined us. I see that you are working and watching with us. Thank you so very much. And on this note, I will go to Lawyer Asma again. But before then, you know the update that I gave you about the law starting of or taking effect from the 1st of January 2027. And that has been the basis of our discussion this afternoon. And I'll read that and get Lawyer to just summarize what it is that we have looked at for us. And it's talking about the fact that from the 1st of January 2027, the qualifying period for unfair dismissal protection in the UK will be reduced from 2 years to 6 months under the Employment Rights Act of 2025. We looked at that. But before we draw the curtains down, let's have a summary from lawyer Charles Asma from BWF Solicitors.
So, ladies and gentlemen, today we looked at the changes to the Employment Rights Act 1996, which is now the Employment Rights Act 2025. There are key things in there, but for this conversation, what we're interested in is the rights of employees not to be unfairly dismissed. The right stems from Section 94 of the Employment Rights Act 1996. But for you to qualify and to be able to assert that right, Section 108, subsection 1 of the Employment Rights Act 1996 talks about a qualifying period of 2 years. And so if you haven't worked with the employer for 2 years, the right under Section 94 cannot be exercised. And that was harsh. What the new law seeks to do is to reduce the 2 years qualifying period under Section 108 from 2 years to 6 months, so that from 1st of January 2027, if anybody was employed from 1st of July 2026, the person after doing 6 months will qualify not to be unfairly dismissed. To be unfairly dismissed, it means the employer did not go through a due process to dismiss the worker or the employee. On that note, the employer would have to prove that the dismissal was fair, and this can be done in court at the employment tribunal. And the employee will have a right to take the matter to court because they've worked with the employer for at least 6 months. The conversation is good because it is helpful for everybody who is an employee and everybody who has worked with an employer for 6 months. However, you cannot bring a claim unless your contract started from 1st of July 2026, and the claim window will start from January the 1st, 2027. For further conversations, for further clarifications, of course, you know the door to knock. Good afternoon.
And the door number is 214 to 218 Tottenham High Road, Seven Sisters, North London. In fact, the 4th floor of the Honor House. That's where BWF solicitors are. Visit them Monday to Friday between 9:30 in the morning and 6 p.m. For weekend appointments, you have to call and book. Call them on 0208 493 7340. Those of you in Ghana, we have an office and the number is 055 589 5959. In all emergency situations, 077 127 61884. Or you can visit our social media handles, all of them, at BWF Solicitors. It's been another wonderful edition of the Community and the Law. And as I said, our resource person and guide and guest is Lawyer Charles Asma. Thank you very much, Lawyer Asma. On behalf of everybody that's been part of this event, to say Thank you. We appreciate you. And we pray that you come again. To BWF solicitors, we can't ever say thank you enough. We believe that you continue to support us so we can bring this empowerment to the community every weekend. I've been produced by Professor Ade, and Sheila Krempan-Ododu have been behind with administration and aesthetics. And BWF Solicitors Family has done the research and the support in the production. My name is Orioko Frimpong. Have a good evening.